Chapter 6, Part 1, or Video 1, Tort Law. Okay, so we're talking about tort law in this chapter, and a tort is defined as a civil wrong proximately causing another person harm or injury not arising from a breach of contract. Okay, notice the word proximately, which is a word you're probably not familiar with because it's mostly a legal term, a term of art here, and basically what we're talking about is a legal wrong or legally causing that injury. And we'll talk about that more when we talk about what's called proximate cause. The purpose of tort law is to provide a remedy to people who were injured or damaged in some way, whether it be personally or their property. Generally, the law tries to put that person, to the extent possible, back into the position that they were in before they were injured. So we're looking at a protected interest that has been violated. Okay, so there are various types of torts, and depending upon perhaps what book you look at or who you talk to, they can be in different categories, but the categories really are insignificant, as will be shown in a minute. Okay, so there's what we call an intentional tort. Okay, we'll talk about that in a few minutes. Then there's what's called an unintentional tort, like negligence. Automobile accidents are generally unintentional torts. If you don't see the stop sign and you run through it, that was unintentional. If, on the other hand, you see somebody you don't like and you run through the stop sign purposefully to hit them, that's an intentional tort. So we got unintentional torts, unintentional torts that we call negligence, and intentional torts. Then we have a category called absolute liability, and then we have a category called product liability. Now, some people put absolute liability and product liability into one category that's called strict liability. It doesn't matter because both absolute liability and product liability are what we call strict liability, meaning that the wrongdoer is liable regardless of their intent. And we'll get further into that later. The last thing to discuss here is defamation, which some people categorize by itself. Others put it in the category of an intentional tort. And I suppose that you could maybe even categorize it as an unintentional tort. But nevertheless, we'll talk about defamation, and we don't need to worry about the categories that much for purposes of defamation. Okay, so when we talk about remedies and compensating the victim, to try and make the victim, quote, whole, as we talk about in the law, or put them back in the position they were in before the damages occurred. These are the types of damages that are generally available in some or most cases. Compensatory damages reimburse the plaintiff, the injured party, for their actual losses. So if your car was totaled, you get the value of your car. If you had to go to the hospital, you get reimbursed for your doctor bills. Okay, so that's compensatory damages. Special damages are quantifiable losses like, well, I guess medical expenses, they don't consider compensatory, they consider it special damages. Those two are oftentimes lumped together, but they include medical expenses, lost wages, and benefits and things like that. So these two are kind of the same. General damages is things that cannot be, you can't put a finger on the amount, but they flow from the injury. So pain and suffering and reputation are examples of that. If you go to the hospital and you have a medical expense, you're going to have a bill that's going to say $15,000. But the pain, you're not going to get something in the hospital that says your pain was worth X. So that's why it's called general damages. Okay, punitive damages are meant to punish the person who caused the harm and deter others from acting in the same way. Generally, with negligence, you cannot get punitive damages because it's accidental. Punitive damages usually require some sort of malevolent intent on the part of the tortfeasor, the wrongdoer. Okay. Now, because of the trend over the last 40 or 50 years with some high verdicts in many tort cases, many states have put caps on the amount of damages that you can get. Generally, there's no cap on compensatory or special damages because those are easily provable and not usually much to contest there. However, with regard to general damages and punitive damages, most states have put a cap on that. For example, a typical one would be $250,000. A jury cannot award any more than that. Okay. With regard to businesses, businesses, of course, have to be aware of torts because businesses may be liable not only for the owners of the business, but for any agents that work for the business. We'll be talking about a doctrine called respondent superior, which means that the principal is responsible for the acts of the agent. So in business, if you have an employee, you may be responsible for their torts that they commit in the course of working for you. We'll talk more about that when we talk about agency law. But at any rate, that's a concern for businesses, as you see up here. And that also may determine what form of business you choose, because some forms of business offer more protection for the owners than other forms of business do. And we'll talk about that when we get to the chapters on corporations, LLCs, partnerships, etc. Now this third one is a key element that I cannot emphasize enough to people who are in business. Okay, and that is acquiring insurance. And there's various types of insurance for people who don't know. So for example, if you own a business and you have vehicles that you use in the business, you're going to want automobile insurance. Okay, but you're also going to want a general liability policy that covers liability if you own a store or a place that you work at, covers the premises, as well as any general torts that you might be sued for. Okay, and that is true, I believe, regardless of the form of business that you choose, that may have some protection. Okay, now why am I so adamant about this? Well, one of the reasons I'm adamant about it is this. We live in a very litigious society. If you're in business, there's a good chance that you will, at some point, if you're in business long enough, be sued. And when you're sued, there's a chance that the lawsuit that's brought against you is not very good. It's what we sometimes refer to as frivolous. Okay, you may win the lawsuit, and you may convince the court to award you attorney's fees for a frivolous lawsuit. The chances of that are not really great. So there is a very good chance that you could be sued in a lawsuit where you did nothing wrong. You win the lawsuit, but you have to pay your own attorney thousands of dollars to represent you and get you through that lawsuit. And it's not much of a lawsuit to run into the $10,000, $20,000, or $30,000 attorney fee range. The advantage of insurance is that the insurance policy will cover the cost of the attorney, and usually the insurance company will provide the attorney. So that's a very important aspect of why you want to have insurance. Okay, so we talked about the classification of torts, and we talked about the possibility that some of these may have subparts to it, and we're going to stop there with this first part and pick up with the next slide. The magic word for chapter 6 is duty.